Good afternoon. Thank you everyone for coming, and thank you to those tuning in online. Welcome to the Glasgow Forum for Scots Law. Very pleased to have Amanda Wyper here today to speak about pensions policy and private law. I think this has been a topic of your doctoral research, and it continues to be an ongoing topic of research. So we're very pleased to have you with us. And without much further ado, I'll hand over.
Thank you, Stephen. Brings us an element of compulsory pension saving to workplace pensions. It was introduced in 2012 and it has led to large volumes of employees and employers contributing into new pension policies. Under the regime, the employers have got to enrol workers into a pension which the employer has chosen, and they have to just meet the certain minimum criteria specified in the AE legislation. Within this, employers have got significant discretion, and they do rely quite heavily on the financial services industry to ensure their compliance with AE going forward. And whilst this policy does benefit many individuals, I've undertaken some empirical research which identifies that there are a number of negative consequences which are identifiable for some individuals. So, for example, employers might not always use a nice final salary trust-based pension scheme. More and more employers are looking to establish and meet their obligations using group personal pension arrangements. Also, within the sort of larger super trust arrangements, there's real differences in quality. So whilst you might have individuals paying the same contributions, employers paying the same contributions, the actual consequences of that could be very different for the individuals depending on how the employer exercises discretion. The employees have very little choice in this whole process. Literally their only choice is whether they're going to opt out of the arrangement or stay with whatever the employer has decided to do. In addition to this, there's no real provision within the legislation for advice. Some smaller employers have complained that at the time this has been introduced, it's been introduced at the point of financial advice having to be paid up front, in addition to these costs, and there is no provision within the legislation for employees themselves to have access to advice. So I think it is important to sort of identify that employers can use a number of different ways to comply. This is the more traditional model, which is less problematic, I would say. I'm probably going to be focusing more on those employers using personal pension arrangements. Here we can quite clearly see the traditional trust-based model, which you would find in a final salary or a money purchase scheme, where the contributions are paid and held separately by the trustees who have fiduciary obligations to the employees and beneficiaries. And that's a much more simple model. More often employers are using a model whereby they choose a pension provider, they might also choose an advisor, and then the personal pension plan is designed for the benefit of the employee, but without the employee having any input in it up until the point of contract. After the contract's effective, the employer will then take a step back and say, well, the employee can then deal with either the pension provider or advisor for information. But there are difficulties there in the relationship, and empirical research does identify that employees are often confused by who owes them any obligation respective information or advice, for example. So hopefully that shows that there's quite clearly an element of employer discretion, and there's also the whole of the financial services industry, which is relied upon, which perhaps has not always shown itself to be entirely reliable in looking out for the best interests of consumers. So there's potential there for difficulties, I would say. Where employers choose schemes without financial advice, this could create some problems. As I've said here, this just highlights the sort of discretionary choices in terms of providers, structure, contributions. Even the structure of the plan itself can cause issues. There's research which identifies the work of the choosing of defaults and how that works for many individuals. If employers simply choose to create a scheme structure which is on the most basic level, depending on how that's communicated to people, they might actually end up paying less over the long term till retirement than we would have done if they'd actually made an active choice or they were given different information. So essentially this paper today is a bit fanciful perhaps, and suggests that perhaps employers, product providers or financial advisors might owe some duties to the employees which are over and above those specified in the AE legislation. So do they owe fiduciary duties perhaps to the employees in this respect? And if not fiduciary, then are there requirements from the contract of employment which would require them to use their discretion in a particular way and give particular consideration to the employees? So, I think as I've said, we're looking here, the question is whether the employer in particular, in the exercise of its discretion, owes these particular duties. The Law Commission recently, as you'll know, looked at this whole question of investment intermediaries and obligations through the investment chain in pensions. And so I suppose in a way I'm suggesting that perhaps the employer acts as some kind of de facto investment intermediary in this respect. But anyway, we shall look at the various aspects and see which aspects are present and which are not. So obviously for any fiduciary obligations to arise, we need to consider who would be owed to, what would the duties be, and in what respect has there been any breach. So having a look at the sort of basic tenets, we might say a fiduciary obligation is trustee-like, and obviously with the trust-based model of occupational pensions, that's quite clearly set up. We have trustees who perform that function. So I suppose what I'm suggesting is whether the employer, in having all this discretion and making these choices, has any additional responsibility here. So dominance is one perhaps identifier of a fiduciary relationship, and subordination, which again you might argue that in the situation we have here, the employee is quite vulnerable in AE because they don't have any right to contribute to any of the pre-contractual negotiations. They have no right to choose a provider or designate what kind of contribution level or their default investment fund might be. Asymmetries in power and information, again, sometimes might identify a relationship which could be fiduciary. Within this, I think the exercise of power and discretion, and particularly the exercise of judgment, is also seen as quite a key indicator in this fiduciary relationship, and Smith in particular is quite keen on the exercise of judgment as an indicator, and with AE, again, the employer has got this significant discretion, and certainly my research has found that employees do place implicit trust and dependency on their employers, but whether this would be sufficient to establish that relationship, I'm not sure. Management of the affairs by one party, again, this again shows there's sort of trust and confidence in this relationship. But again, it's not clear whether that would be sufficient to establish that it's fiduciary. Again, as I've identified in E, the assets to some extent are controlled by the employer, because it's the employer that deducts the contributions from the employee's salary. The employee doesn't have the contributions in their salary to pass on. Takings which are fiduciary-like. In terms of the advisors in the relationship, the complication whereby employers engage normally the product provider or financial advisors to assist setting up the plans. The employer is the client until the point that the contract is effected, and then obviously the employee has a contract directly with the provider at that point. So there may be obligations there between the providers and financial advisors to the employer, but not necessarily to the employees. However, in the dealings that these parties have with the employees, it might be possible that they do undertake some kind of fiduciary responsibility. And the question of when does information become advice is a really difficult one. There's a lot of case law about this, and I think from what I observed from speaking to employers in particular was that they are so cautious about giving anything that might be construed as advice that the employees are now effectively starved of information because the product providers don't want to appear to be providing advice, neither do the employers. And so the consequence is that there's maybe information gaps. But say an advisor or a product provider does provide sufficient information that is perceived as advice, then perhaps there's a basis of responsibility here on a voluntary undertaking. So I shall move on. I mentioned before that the employment relationship obviously can be fiduciary, but obviously is not always fiduciary. Because the employment contract will say very little about pensions. AE has been imposed by regulation, and so the question of voluntary assumption of responsibilities seems very difficult to make out. But there are still some aspects of it. In relation to sort of questions, other identifying factors of fiduciary, Again, loyalty is one which is frequently identified as being a key duty from which all the other duties would flow. And that makes it difficult in the employment relationship to say that the employer owes this duty there. But judgment might also be seen as being a main indicator. And again, it's this exercise of judgment and discretion which could perhaps set up these duties here. So I think what's saying, in a nutshell, on this aspect is that many of the indicators of fiduciary relationship are in evidence with AE, but it seems unlikely that this would be a successful challenge. So if employees are unhappy in 20 years' time and they feel that their employers have made very poor choices, poorly exercised their discretion, then it's unlikely, I think, at present that this is going to be a successful route of claim. However, it might be more successful if they were to challenge the employer on the basis of agency. Again, obviously there are specific fiduciary and non-fiduciary duties that might arise here. So you might argue, again, that in taking charge of the contract, choosing providers, making the deductions, they effectively act as an agent of the employee. We can see that there are a number, again, of identifying factors here. And again, I am only talking about the situation where we're looking at arranging personal pension contracts rather than whereby the employer nominates a trust-based scheme. Again, we have a difficulty in that there are very few contractual terms specified in relation to pensions and in particular in relation to auto-enrolment. But for agency, obviously we might be able to bear this through the sort of facts and circumstances. So again, we could look at these questions of loyalty, reposed trust and confidence, cessation of power, perhaps to control funds and make decisions and contract on behalf of the employee. So in this respect, I suppose we're saying that the employee has granted authority to the employer to contract with any pension provider it chooses, although with AE the employee is simply advised of what's happened, so that perhaps might go against the finding that it's an agency situation because the employee has very limited information and power. The characterisation, again, by the parties could also be significant, but it's not determinative, so that might be another argument. I think agency could perhaps be more successfully argued than the sort of general fiduciary obligation, as we do have a number of facts and circumstances that might lead to consideration of it. And one of the sort of areas that causes major issue again is this information giving, whereby employers are giving information that's perhaps being passed on by advisors, and whether the information given is sufficient. Obviously, if there was an agency situation, then there would be a more significant obligation in terms of ensuring that that the agent properly passed on information and that it was understood, rather than simply passing on generic information. Also, I think, as well as the fiduciary duties of agency, some of the non-fiduciary duties, including this exercise of skill and care, would perhaps require the employers to exercise more consideration or more skill when making these discretionary decisions. If they're able to demonstrate some skill and care in choosing their providers, etc., then employers shouldn't have anything to worry about here. But I think the difficulty is that some employers might be reluctant to pay for advice, and that might be at the start of the arrangement or perhaps in the middle of an arrangement where by they have a failing or very poorly performing scheme, but it's going to cost the employer to actually change it. Currently, as long as the scheme meets the bare minimum requirements, there is no issue there and there is no remedy, whereby if the employer acted as an agent and they were seen to be doing something for the employees that they would have made they would have made a better decision for themselves, then they're going to fail this skill and care test. And I think we have to recognise that the cost of obtaining advice up front is now really prohibitive. So many smaller employers, and certainly most individuals, are probably not going to be seeking financial advice in relation to their pension primarily. They may seek financial advice in relation to other matters which are seen as more of a priority. But again, perhaps more empirical research is needed on that. So again, I suppose what I'm saying is that I'm not suggesting that the whole relationship is an agency relationship, but perhaps we could have a limited agency situation in respect of these discretionary AE obligations. Again, as part of that, I've identified knowledge as being particularly key because I have identified in my own research that both employees are looking for more salient, specific information, but in response they're being given more generic, voluminous information, which they find to be a barrier to activity and understanding. So I feel that something somewhere needs to be improved. And perhaps if we were to have a class action and go through all of these possible issues, then employers might feel that they would want to ensure their procedures were clear and fair all the time, and it might level the playing field a bit. Okay, I will quickly turn to the contract of employment. I've got another, what, 5-10 minutes, or?
Yeah, take as long as you need, actually.
Yep. I don't want to, I feel slightly like I'm telling you all about everything you already know about agency and fiduciary.
Not at all, no. Please keep going.
So, okay, well, turning now to probably what I think is the most likely basis of any claim is the contract of employment. So even if there isn't any fiduciary or agency obligation, I think the contract of employment itself may create obligations in relation to the particular form of implementing AE, which require a standard beyond the current statutory provisions. Employees derive benefits for occupational pension schemes from the contract of employment, so that's obviously the first place we would go. But in my experience, most contracts of employment say very little about pensions, simply referring to the fact that they've complied with AE and also referring to member booklet information, other literature, which can then be more flexibly changed in the future. So the contract of employment is the control mechanism, but again, we have very little in the way of contractual provision about AE and what the employer will do other than comply with the legislation. And I think, courts have been willing to use fiduciary obligations in the past to correct some imbalances of power, although I have said that the whole contract is not in itself fiduciary. So essentially here we're wondering whether there are some fiduciary obligations within the contract, or even without a fiduciary obligation, if there are express or implied contractual terms that might require the standards of exercise of discretion to be higher than those specified under the statutes. So I'm not going to go back over the fiduciary question too much, other than to say that I think there is a lot of confusion within the employment contract with questions of implied terms of mutual trust and confidence, but it's not the same as fiduciary, and loyalty does not equate to fiduciary either. So there's been much debate about it, and House of Lords has determined that in some instances, obviously, we can have fiduciary duties, but in very specific circumstances, there's not to be read going forward as an ongoing obligation. Most of the case law has concerned whether employees owe the fiduciary obligation to the employer, and obviously what I'm proposing is the other way around. So, as I said, it's perhaps slightly left field, this paper, but I do think it's sometimes we need to think about exactly how something functions on the ground. Again, the lack of explicit contractual terms is problematic, but it's not fatal, because we can see from practice what's actually happening and what the employers are doing. So implied terms. So the implication of the term, again, should only spell out what the instrument means, and the courts can sometimes imply terms which leap over principles in contract to protect workers. So on this basis, implied terms might be read into the contract whereby the employer exercises discretion, and they should do it in a particular way, that they should take care when they're doing it, and they should show that they have a fair process in choosing it. The duty of good faith, again, is a differing obligation from a fiduciary one, in that it doesn't require one party to place another's interests over their own. And again, this is always quite difficult, because the employer does have its own interest in ensuring that it's running a business and doesn't want to have increasing costs beyond that which are required. However, the implied obligation of good faith could be read into the contract to fetter the exercise of the employer's rights to some extent, so that they are exercised in the same way that the employer would exercise them in their own decision making. So whilst the employer has got the right to consider its own financial interests, the implied obligation of good faith does ensure that decisions must not be undertaken in a way which undermines trust and confidence. So again, this question of what can undermine trust and confidence is another circular one, and many aspects, we could argue, might undermine trust and confidence. But what I'm essentially saying is, could a lack of care in the exercise of discretionary powers amount to a breach of this duty and lead to a lack of confidence in the employer, particularly if the employees have placed this trust in the employer. And I think we also have to recognise that this is all taking place in the environment of the workplace, where there are different tensions and conflicts, so it's not entirely neutral either. I think, obviously, if the relationship is categorised as fiduciary, then there would be a positive obligation to disclose any negative consequences of any actions undertaken. But implied terms perhaps might require more consideration than the employer currently thinks that they are obliged to give. In terms of trying to identify what might breach the implied term of mutual trust and confidence, case law seems to establish that the employer's motives are irrelevant, and what is significant is the impact of the behaviour on the employee rather than what was intended. So again, if we think about that in terms of the sorts of decisions, if the employer was to be aware of the fact that they had a poorly performing scheme or an expensive scheme, or so there's been questions about some of these super trust arrangements about whether they're really viable going forward, is that the sort of thing that the employer should be taking more responsibility for and making a better financial decision going forward, even if it costs them money in the short term? So I think that there has been an expansion of this implication to try and rectify imbalances, and I think it might require a sort of more proactive manner of approaching care standards by employers. Whether this is ever considered, I suppose, depends on whether a class action would be brought, because I think the cost of any individual bringing a claim against an employer is quite prohibitive. And the problem that I've always identified with pension products in particular is that whilst they are a very significant asset to many individuals, they don't appreciate them as a tangible asset until the point that they want to receive a benefit from them, which may be 20 or 30 years down the line. So we may not see any problems forthcoming until this policy has been in operation for quite a long time. But I think it's important to consider the issues now. And essentially I'm saying it may require some objective justification of exercises of discretion. In terms of duty to advise, again, the information requirements of the EU legislation do require certain minimum information to be given over. And part of that is that the employer is responsible for the information, even if it's contracted with the pension provider to hand over the information on its behalf, which can cause some confusion. I did speak to some employers who felt that they were receiving advice from their provider, but when I spoke to the provider, they said they didn't provide advice. So I think sometimes the contractual basis says one thing, but actually the reality and the person-to-person contact can create a difficulty there. So I think it's difficult to see where we can go with this duty to advise. It seems unlikely that anybody is ever going to require an employer to provide advice unless the employer has actually undertaken to provide the advice themselves. And there are a number of cases where employers have found themselves in that situation, but I think it's important to remember that financial and pensions advice in particular is seen as being a very specialised advisory capacity, and most employers would not be expected to do that. The employers who have found themselves responsible for that are ones who have either provided a member of staff who held themselves out as expert at doing pension transfers or something else and have undertaken to help an employee or do something on their behalf. And whilst they might not have the technical skills in actually undertaking to do the work, they've then made themselves responsible for the provision of advice. And I think there's a real difficulty here in terms of trying to provide a balance between providing sufficient information for employees and overstepping that into the provision of advice. And I think there is a real fear amongst employers who I think have been advised by their employment lawyers not to say anything about it at all, that there are gaps that are now appearing of information because employees can't pay for advice because they can't afford it and no one else wants to give it. So again, if anybody was to step over and take on board the responsibility for advice, then maybe there would be a basis of claim there. And again, there's an argument about whether there is any duty on employers to ensure employees avoid economic loss. And the general principle, again, is that there is not such a duty. There is no implied term to prevent economic loss unless they've actually stepped out and undertaken to do that themselves. And again, where employees have relied on information as advice, that will be insufficient unless there's some reason why the employee feels that contractually or otherwise that they should be able to rely on that as advice. So, as I'm just going to finish up here, pension providers and advisors seem to be very well informed. They tend to operate on fairly standard form contracts with exclusions from liability from most of these aspects, and much of the literature that I reviewed does say in print, quite small print at various points, that they are not advising the employee. So contractually, I think employees would struggle to make out any basis of claim. unless there were some employers I spoke to who used to provide a financial advisor on a sort of drop-in basis, but many of them were considering stopping doing that because I think there was a real difficulty in who was the client and who was paying for it, and I'm not sure that all the advisors had really thought that through either. So I think we'll see that being phased out, which is problematic for employees because actually what they need is more people to give them access to information and advice, and the reality is that they're getting less and less and more volumes of paper, which is often seen as being a bit of a barrier. So I think it can cause confusion, both for employers and employees, and leave lots of unanswered questions. So in conclusion, I'm saying that whilst it can be very beneficial and is being hailed as a massive success, I think we have to recognise that there are some unintended consequences, and for some it may not be the best thing for them. It's not going to be apparent for a long time. I've identified, I've sort of done a quick run through everything you want to know about private law, and identified that there's some possible avenues of claim, but they're all quite spurious perhaps and might be quite difficult to make out. So I do think that we need some further statutory clarification on this point. And I think, again, it's not just about auto-enrolment. We can see there's a pensions green paper this week, which is looking at changing contractually accrued past service benefits. We've got creation of lifetime IVAs in sort of competition with pensions and early access to pensions. There's a sort of constant churning of pension policy, which does have an impact on individual contracts, and I think it's timely that we should consider how we deal with that, where the legislation does not specify and leaves gaps, which I think it does here. Thank you.
Okay, thank you very much. Can I just ask a question to start with? What's a super trust? Because that sounds quite exciting. I'm like, is it like lots of employers kind of clubbing together to create like a mega trust? Yes.
Quite often, you would find a lot of charitable organisations used it in the past, whereby they didn't want to set up their own occupational scheme and incur all the sort of running costs. So it's like you have a sort of section of the pie almost you put in, and you have an aspect of it. There have been a few issues with some of them where there's been funding issues, and then you don't want to be the last employer left with all the costs of it. And also there has been a rise in creation of new trusts, and some of the governance has not been as good as others. And I think that's part of what I'm trying to say, is that all pensions are not created equal. So I think there has to be some element of reflection, and I'm not sure that all employers take their responsibilities as seriously.
Yeah. Okay, thanks. Just start with maybe an easy question, but does anyone else have a question? Yeah.
So, maybe one way to come at it is from the perspective of remedies. Clearly you're sort of going down the private routes, but I mean, generally you could say within the financial space, there's not a lot of private enforcement going on. It's mostly public enforcement that we see. So, one of the questions we might ask is, are there mechanisms, and some of that's around cost, and it's just much, because you've got things like the financial ombudsman, you've got potential complaints to the regulator, so you've got well-established, I say adjudication and enforcement mechanisms in the public space. Are there ways to resolve the problem in the public space? Now, some of the difficulty around that is around status as a customer, because normally you can only complain or bring something to the ombudsman if you're a customer. So, would categorization of the employee as a customer of either the advisory firm or the provider firm, which we could probably get there in some way.
Well, on the model you're discussing, they are.
Well, they're not. As I understand it, it's the employer.
The employer sets it up, and
Yeah.
then eventually the employee will hold a pension policy
But
with the provider, but they're not.
But is that direct level? Is that, I mean, what is that? Is that a third party right? Is that a direct contractual relationship?
They have a contractual relationship which is established by the employer on their behalf, yeah, and then it's their personal pension policy.
Okay. I mean, if that's the case, the employer looks much more like an agent.
Yeah, it's a broker.
Yes, creating an individual contractual relationship between the employee and the provider or the advisor. I mean, in which case the public space becomes much more, because then I think we could say that the employee is a customer for that purpose. Yeah,
clearly. Yeah.
So so then we open up the ombudsman. Now, the benefit of the ombudsman as well is you can actually cut through all the legal analysis, because the ombudsman operates on a fair and reasonable basis.
Right.
Doesn't have to take into account the law. So
Yeah.
I don't know if any of these cases are going to the ombudsman, but they would be that would be a good road to go down if there were kind of clear grounds for dissatisfaction.
I think so far there hasn't been anything really, and I've been looking at all the pension regulator cases, and they're all very procedural. And I think that's why I started to think there's gaps here, and I'm not sure who's looking at this. So it would be really interesting and subject to bring an ombudsman case, but I don't have one.
Right. But you've been looking at the pensions regulator is the occupational side, isn't it?
Yes,
Yeah.
but it is in charge of AE and compliance with AE
Okay.
generally.
Okay.
So
I guess the question is whether these matters could be brought before the financial services ombudsman rather than the pension regulator.
yeah, well, I think the issue, if you start looking, I started to look at the sort of, you could use, say, COBS as an indication of what's good practice, not good practice, and you could go around it that way. I think the problem is that there is no relationship between the provider and the employee at the sort of pre-contractual stage. So normally it would be that stage that you would set up your basis of claim.
That's a difficult one in a sense, isn't it? Because I mean, if the employee as agent is setting up the contract on behalf, if the employer as agent is setting up the contract with the provider on behalf of the employee, then in the standard agency analysis, wouldn't we say that the pre-contractual remedies must remain in place?
Yeah, the information.
Yeah.
I think there would be perhaps two issues. One is that in many cases, I guess there is actually a moment where there's direct contact between the employee and the provider when they choose to opt in, and that's how you establish the direct contact.
Opt out.
Yeah.
So the direct contact is from the employer to the employee.
Okay.
They tell the employee this is what's happening, and then they'll say you're now enrolled, you now have
Okay.
pension,
And so
and then they will have contact from the provider saying this is your pension, you've got 1 month
Yeah.
to opt out.
Yeah, well, I mean, in that case,
Yeah.
the analysis is potentially quite simple, because the information is provided to the employer as the employee's agent, and therefore is deemed to be have been provided to the employee. And so the employee can plead any failure to make proper disclosures to the employer.
So the agency, if the employer is an agent in that situation, it is much easier. But I think
it's pretty. If the employer is entering into a contract on behalf of the employee, as they are, then that's agency.
But it's not necessarily a voluntary assumption of that contract, is it? Because it's been required by the legislation.
But there are lots of situations where somebody is put in the agency relationship by statute or by law. So you can be made. You have obligations analogous to agency with relation to your children, and I can't do anything about that. Also here the dispute would potentially be between the employee and the fund provider. So you'd be going after them through the Financial Services Ombudsman. So the employer has no skin in the game to say.
That's only if the provider has done something wrong, whereby if it's the employer that's chosen a rubbish provider.
That's a different issue. But there is a relationship with agency. I think the issue there is perhaps more going to be, well, what's the standard of care? And if the standard of care is a sort of reasonable person in the market, and if they're all rubbish, then I think, and as an employer, generally we can't expect them to be very good because it's hard, and it applies to anyone who has a nanny or whatever. Then the basic standard of care that's going to apply to employers in terms of how good they're expected to be at picking good pension schemes must be a very low one.
But if you're in a situation, say, where they have chosen, or most employers seek some kind of advice, or use the government sort of nest kind of guaranteed scheme, which is guaranteed at a sort of kind of level, but they don't choose that. They choose something else, and then it actually goes bust or something in 20 years' time.
Well, yeah, then potentially because of
I suppose, which I appreciate that it's a bit tenuous, but I'm.
Are these automatic enrolment schemes encompassed by the pension protection scheme?
Well, only if they're occupational final salary schemes, and then we don't really have this problem. Most employers are probably either using an existing arrangement that they've got and making changes to it, or they're setting up a new group personal pension arrangement. And actually, there has been a bit of a tightening of the rules, because I think they brought the legislation in 2012 and then realised by about 2014 that actually a lot of the scheme governance was terrible, it was really expensive, and it was basically eating away all the contributions. So there's been an adjustment, but I still think there's not parity between them, and the pension protection fund will only apply for the final salary one. So most employees.
And these wouldn't be fine. These wouldn't be fine.
No, most people are not being offered access to that. Even people who have final salary arrangements are generally being moved on to something else.
And I suppose the desirable thing about doing it through a common law remedy is that potentially your damages might be higher. I don't know how much you get if you go through the ombudsman and it's found to be that you were given bad advice, what rate of compensation you get.
I don't know. I know the government, I think the question was raised about fiduciary duties in the context of these other reports, and I think the government put something out to say it wouldn't apply here, but without any basis or argument. So I'm not sure whether they were just sort of trying to say. But I also wonder to what extent the Ombudsman would want. Like you say, I'm not really sure to what extent the Ombudsman would just make a determination without clarifying on what basis there was a responsibility.
Well, I mean, they have made determinations in the past where they've said, this is not encompassed by a legal duty, but we think it's fair and reasonable in the circumstances. And these have been cases that have, some of them have been lead cases that have led to chains of other claims being made as well.
Yeah.
I mean, in terms of the amount, I mean, again, I think the ombudsman decisions, from what I've seen of them and what I can remember, they're not quite as rigorous in terms of the kind of evaluation of damages. They tend to be kind of more saying, there was so much loss, there was so much lost, and that's it. They don't have that kind of.
This thing's awful.
Well, welcome to a world where law probably isn't seen in the same way that we see it. It's seen as a sort of barrier to resolving problems rather than a facilitator.
What is your loss though? I can sort of understand 20 years from now when your pension turns up and it's worth nothing, then you can be, I suffered a loss, but if today I don't understand my occupational pension scheme, which I don't, then what is, on what basis am I seeking a legal remedy?
Well, I suppose your loss might be purely performing scheme, say, or a scheme that operates on a much bigger expenses basis than an alternate scheme, and then you could say, actually, you'd have to work out, if I'd paid these contributions into that comparative scheme, then over 20 years, that could be quite a significant amount. Alternatively, if you've been given information which leads you to believe, and you say rely on it as advice, if it was advice, that you you will have a reasonable pension and actually you've not paid in enough contributions? Is there an element there of saying, well, I relied on that advice and it was wrong? I think most of the issues are going to come out of poorly performing arrangements, or maybe even some that go bust, and then that's problematic, because if you put money into something that's some kind of personal arrangement that's not going to give you a return, then that's problematic.
But from the point of the legal remedy, that's the easy one to stop, because you can just compare it with a good case.
But I think there have been a number of questions raised about some of the new arrangements that have been established on the back of auto-enrolment, because obviously there's huge expansion in the market and volume of contributions going in, being channelled into pensions that were maybe being channelled somewhere else. But the governance has been slow to catch up, so I think that it's not beyond possibility that there will be a bad result somewhere.
Yeah.
I hope there's not, but there may be.
Sorry.
I feel like fundamentally my kind of concern about this is the fact that you might be a person who's got a pension scheme that you don't understand and have no remedy against because nobody has given you advice at any stage. Your employer didn't give you advice, your pension provider didn't give you advice, which is how your pension providers and employers deliberately choose to operate. Like, from the government perspective, I don't think the government cares about that. Like, I think from the government perspective, that is not their, all they want is for the state not to be responsible for it. They're not really interested in whether or not it's, I feel like from the government perspective, like, on my own head be it. It's up to me to...
I completely agree with you. I think this is just one sort of small tranche of my bigger thesis, which basically says we need to do a lot of work on the default position, and somebody needs to be responsible for paying for some advice for somebody somewhere, because even with it, small employers probably should have access to some kind of advice, and maybe there needs to be some process, because employees clearly have generic advice, and there's advice provided at the point of drawing a pension, but not at the point of accumulating. And I think it has become quite complicated, and we are seeing a continually sort of new policies that sometimes conflict with other policies. I mean, the early access to pensions being brought in after everyone's been enrolled to have a pension, that suddenly you can then access your pension and just spend it, seems to me to conflict and probably should require advice for individuals. But I think, this is just one aspect of what I see as a bigger problem.
Yeah, I mean, I think that sort of general lack of understanding of pensions that just generally is an interesting contrast, or the way that it's dealt with legally is an interesting contrast with the way that we develop rules of succession. So in succession, it's sort of similar in the sense that pretty much everybody's going to be affected by it. It has knock-on effects potentially for the state if it's not dealt with properly, because then people are making benefits claims. So, and there is an understanding that no one wants to think about succession, no one wants to think about making a will, no one wants to really know what the rules are unless you're very rich, which, like with pensions, then you will take financial advice. So there's a sense that we need to make sure that the default rules are as straightforward as we can make them, and achieve particular policy ends, and there's a sort of element of protecting people built into the law of succession, whereas with pensions I feel like that's all just been stripped away. It's like, even though there's quite a lot of parallels, and everybody pretty much nowadays is probably going to have some sort of pension, or that seems to be the way that they're setting up employment now, and nobody really understands pensions and nobody wants to think about it. But the government just, or the lawmakers just seem to be like, we're not going to worry about making it straightforward, or hoping that people can understand it. We're just going to wait till 30 years from now and then go, oh my God, we've got all these people that are too old to work it anyway.
I think one of my big issues that I have with the way pensions legislation and policy is written is the short-term nature of it. It's very political, changes every time we have a new government, but actually there is a really strong argument, I think, for a pensions commissioner that has a much longer-term approach to dealing with something which is a long-term financial product, and it works in a long-term financial market. We tend to, and as a big institutional investor, we have quite a big impact on the UK market, I think, as well.
I remember the government minister who introduced this. He was a Liberal Democrat, wasn't he? And
it was introduced originally by the Labour Party, and then it was ratified by the left.
the coalition government.
Coalition government, yeah. Steve Webb was in charge of it. Yeah.
That was it, Steve Webb.
Mhm.
He's a Liberal Democrat, isn't he? Because I've heard
No, he's Tory.
Was he?
He was in the, he dropped out early in the most recent Tory leadership election.
Did he? Oh, I've not been following it close.
Stephen Crabbe.
Stephen Crabbe.
Steve Webb. I don't know what parties. I know that it was a Labour policy that was introduced eventually by the coalition government with unanimous support.
Because I know that whoever it was on Moneybox Live quite often, and he fell out of favour and was actually quite disappointed with the implementation of it. So the broader idea actually of auto-enrolment was meant to be, like, I think, quite paternalistic in that it was ensuring everyone had a pension, or at least everyone had to face the decision, and it was informed by an idea that people don't ever make a decision, so let's do it by default. But there's then, through the working out of it, the advice issues become incredibly difficult, because I know that here at the university they did auto-enrolment, and then they offer group sessions that you can go along to speak to someone about. Now, I don't mind, I'm not going to go, but if you go to a group session, that's not really going to be sufficient advice. There's that gap opening up there, I think.
Well, why not solve two social problems at one time? Auto-enroll everyone into the government's debt. Yeah?
But I think that
We are.
On the
a little bit more.
I think that's a really fundamental question, because it was I think it was paternalistic, and it was motivated by a lot of work in behavioural economics and all of these things. But fundamentally, the government decided that they were going to drop it in the private sector rather than, saying actually everybody's going to pay 10% on top of NIs or whatever you want to call it. It's some kind of superannuation, and that's what that is, and we'll administer it and everyone will have the same. In doing it this way, there's great disparity. There are winners and losers, and I think that my work is just trying to identify for those who are the losers.
See, does anyone else have?
I do have a question.
Yeah.
Is what you're saying directly relevant to this? Because my question is going to take us off completely.
I'm going back to private law.
So, okay, well,
keep going.
I was wondering about fiduciary duties, and supposing that we assume that there are fiduciary duties, what good they would be, given the content of the fiduciary duty?
Well, I suppose in terms of the exercise of discretionary power, in particular in the sort of decision-making process, if they act as fiduciary, then they have to act with the employee's interest rather than necessarily considering the fact that the employer doesn't want to spend money on advice or doesn't want the hassle of having to implement a new scheme or arrangement because actually they just did it 2 years ago or something like that.
I guess the difficulty with that is that, at least in my view, ultimately the fiduciary responsibility comes down to a duty to avoid a conflict of interest. And so there's not much of a positive obligation there. Trustees have responsibilities to take certain steps to the normal management of the trust assets. But I don't think really flow particularly from the fiduciary nature of that relationship.
I think there was a question, there was some discussion about this in the Law Commission paper.
The same issue,
and it was the same issue, and it was, I think they did fundamentally say that whilst the trustees have a responsibility to monitor the investments, the employer would not have in the same situation, and I suppose that is the question there. So,
but I guess what I'm saying is that I don't think it's the fiduciary bit.
I think another way of saying what you're saying, Johnny, is to say there is no enhanced fiduciary duty of care.
Exactly. Being a fiduciary
you see that in some of the cases, like Montague against Bristol and West Building Society. That talks about this kind of idea, and so I tend to agree with that. That probably although the fiduciary bit brings other protections,
but it does bring a duty of care that's not apparent in the AE legislation.
Fiduciary duty is not to be evil rather than not to be stupid. And the problem here is people being stupid.
Yeah, I see what you're saying. Yeah, I mean, I suppose my preference is the agency argument in that, and I think agency gives you, obviously, the fiduciary and non-fiduciary, and
fundamentally, what you need to establish is the duty of care here. You don't even, I think, necessarily need agents.
No, I think you do. You need to establish a duty of care, and I suppose that was a process of me trying to work out whether there was any way of establishing that there was a duty of care beyond I've set up a scheme. I don't care what it looks like, but I've done it, which is currently all that's required.
Yeah. I mean, there might be some interesting, a bit of an angle in terms of people's responsibilities and the exercise of statutory duties as well. Because when a statutory duty is conferred upon somebody, and well, at least I would think this kind of statutory duty, if a discretion is conferred upon you, you're required to exercise that discretion, which means making a reasonable choice. So I think the hook I would prefer is the statute duty of care.
There's also the cases on exercise of contractual discretion which say you just review them on public law reasonableness grounds, which probably isn't very helpful for the most part.
Does that not bring you back to your point before about the fact that the standard of care is probably very low? So you do have a duty to exercise your discretion reasonably in implementation of a statutory duty, but then if everybody's being stupid about it, then...
Which is why I think if you go to the contract of employment and you start to go through that basis, then it may require you to sort of establish that you've followed a fair process and actually set up a procedure in the way that you would for, say, dismissal, and that you can establish that, then maybe that would be sufficient. And if there is no process and there is no fair procedure, then you maybe could use that contractual basis.
Because there's an interesting thing here which, well, to me might be interesting, which, picking up on what you were saying, I was thinking about this lag that we are perceiving between when actually the advice or lack of advice or the wolf has been introduced to the employee, and then when the action is raised, and then what's the standard of care? Well, what's the standard of care now? You're seeing is quite low, but in 30 years' time, will the court feel compelled to raise the standard of care in view of what it now knows? Like there could be it should be judged on what the standard of care was at this junction, rather than in the future. I suppose if you do it by a rule of law analysis, but sometimes the common law can be developed in such a way where the judges feel, in an employer's context in the 19th century, there wasn't much protection for employers, and then the standard of care started to change or become more of an important thing. I'm riffing on this idea of flying a kite about how it's going to develop in the future.
It feels quite hard to me to kind of, say if you're a really conscientious employer and you did take independent financial advice from an expert about who you should launch your who you should set up your pension scheme with, and then you follow that advice, and then the pension scheme goes bust. The employer is unlikely to really have any claim there, so long as the financial advisor can show that they. And because we understand so little about how financial markets work, or it's so difficult to see that far into the future.
But the employer should have no liability in that case either.
I know, but that's so. I'm just sort of saying, a very conscientious. You wouldn't be able to claim against a financial advisor, which is who we would expect a very conscientious employer to go to.
Yeah.
But then we're expecting the employer is going to have some sort of liability for investing in a crap pension scheme. Or a pension scheme that turns out to be rubbish. I mean, I understand the point that you're making, so then you've got to have a process where the employer can be, I really tried, I thought this was fine.
I think if you codify slightly maybe the requirements there, that might be sufficient to improve practices across the board, so that employers are maybe giving it more consideration, or maybe that would just mean that everybody joins the government nest scheme, alternative approach.
So sort of improving the level of good practice.
I think I think we need to somehow iron out the disparity that's currently there, because everyone's pretending that everyone has the same pension because everyone's paying in 8%, or will eventually be paying in 8% of the salary contributions, and that's not enough for a start. And you know, that doesn't mean that everyone will end up with the same amount of pension at the end of that.
In relation to the provision of information issue, I did wonder, like, there's a certain tension there, because basically you were saying, I think rightly, that the more potential liability there is, the more people tend to clam up.
Yeah.
So if our primary concern is with bad information or lack of information, people being maybe rather than imposing liability on employers, we should be giving them indemnities.
I think there's definitely something needs to be done with the information, and whether it's you know, just generic financial advice services that are offered to people at the point of drawing the pension, maybe that actually needs to be rolled out. Again, the government would have to fund that, or somebody would have to fund some kind of, you know, or an indemnity, like you say.
Yeah, exactly.
Or a clarification. If we have some statutory clarification that says employers will not be responsible where they do this, and employers are given a process and everyone follows the process, then there's clarity there, isn't there? And nobody is worried about a claim in the future.
Although then people would follow the process very blindly, and
that's what employers do.
They wouldn't give any useful information then either.
Yeah. I don't know. I'm not sure what the answer is, but I do think that currently there's too much uncertainty about it.
Yeah. I mean, maybe what it brings out is that fundamentally the choice traditionally has been between the state bearing a burden or the individual bearing a burden. And this was an attempt to get to it. Imagine some third party that could somehow bear this burden. And it turns out that that third party doesn't exist, and we need to face up to stark choice. Either we pay or we accept people dying in poverty. And just run our elections on that basis.
Yeah,
I'm not sure about politics, Julie.
I'm not sure we've actually got a third party, because the reality is that it's really, you know, it's the individual. It's just, you know, it's just the provider is just, you know, the mechanism. It's the individual is ultimately bearing risk and cost.
But I think we're trying to.
The protection is that it's the employer that somehow the paternalistic aspects of it that Stephen has identified, this idea that it's the employer that's being burdened, but they're not.
And we're kind of, I mean, this is all about, in a sense, looking for somebody to pin the bill on when it all goes wrong in the future, actually. It's just
or else individuals die in poverty.
Yeah.
Have you got an impression of, like, the standard of product that's out there? Is it actually quite good, or?
Even this feels like you're just looking for personal advice.
No, because behind this, I'm thinking, you know how, like, there's going to be an inquiry into the competitiveness of some areas of financial services. I think, is it into advisors? In financial services,
there have been inquiries into that.
So I'm just wondering if, like, because this is a whole new market potentially that's cropping up, and there's all these new products coming out.
I think there are a number of provisions in relation to those that are accessing pensions at the drawdown stage. There's a sort of very specific procedures that need to be gone through by advisors before they could allow somebody to basically take their pension and spend it, which is now possible. And you can convert a final salary pension into a money purchase one in order to do that now, which seems to me a bit dangerous. But I think that there's variation. I think the biggest problem that the employers I spoke to seemed to have was administration. I think a lot of the systems don't work, so one payroll system doesn't necessarily work with that, and then when you're trying to send it to the provider, and also doesn't work with HMRC, so there's quite a lot of workarounds. And then if you have individuals who've maybe got some kind of different circumstances, there's problems with contributions being deducted and not paid, or paid late, or just disappearing on the system. I think there's been lots of administrative glitches, but I think, you know, in general terms, I don't think the financial services industry is what it is. And I think just because you say that they have to provide a product doesn't mean that they have to provide it. So you have to accept that, you know, that they have an interest in, they'll only sell products if they can make money out of them as well. So part of the problem has been that there's been an element of cherry picking, I think, with the sort of lower paid employees. Nobody really wants to take them and have policies for them. So we'll take your higher paid ones, but the lower ones can maybe go on to the nest arrangement, and then you have employment relations issues, if you had to run 2 or 3 tier pension arrangements, and quite often employers do have that, but that can cause other employment issues.
Well, I suppose that answers the question. I was just wondering if an employer walks into the pensions corner shop, are they only being offered Milky Ways, or can they also get like Mars bars and Lime bars?
It depends which corner shop you walk into.
It does.
And there are 2 variants, you know, there's the independent and the non-independent.
Just because if that if coming back to if we're lumping it onto the market, is the market quite static just now with just all these tough products, or at least anti-competitive?
Well, I think there's maybe a sense that actually the demand is going to outstrip supply to some extent of products that are, because the market's not going to be willing to provide everything. And one of the problems that has been identified is maybe if an employer has had an arrangement whereby they pay into somebody's own personal pension arrangement, they maybe pay 5 or 6% into that, and then they go to that provider and say, can you make this an AE compliant scheme? They'll say no. You've got to take out a new scheme. So then they've got a contractual arrangement there with that person, so they're then got to try and sit down and say, well, I can't pay 5% into that and also pay 4% into that, but contractually I'm obliged to pay that. I'm actually statutorily obliged to pay into this one, and what we're going to do. So a lot of the providers have not been that helpful, I think, in that situation. And that's one of the things that people were reporting to me, that they were unhappy that they had their own personal pension policy that they had to stop receiving payments into because it wasn't AE compliant, and the employer wouldn't pay into both. So,
is there a cap on the expenses? That can be, you know, like a percentage, you know. You know how there used to be these stakeholder products that had capped expenses?
They've recently capped it, so 0.75, and they can't add. There's all sorts of limitations that have now gone in, but they used to be able to charge extra for, looking after a deferred pot and things like that. But everything, they are now dealing much more strictly with the governance, but over the last couple of years, really.
So they can't sort of rip you off on the cost side. They can clearly not do it on what they do with your money, but in terms of what they charge you, you're probably going to be, you are going to be.
Well, I think that another issue that I've come across is that the default fund is the one that has all the restrictions on it. So there's no incentive for people to say go into a higher risk fund when they're younger, which might be a strategy. You know, an occupational pension would generally go for higher risk products, you know, for the youngers, and then they de-risk as they get older, whereas an individual will be put off doing that because the default fund is seen as being the cheaper fund. So even if the other funds outperform it, people don't want to move. So this whole question of defaults, and they have tried to use behavioural economics to do this, but I don't think they've necessarily used all the lessons. They've picked some of the lessons and ignored some of them, and the consequences therefore are you almost get a sort of lowest common denominator effect, which is okay for some people, but maybe negatively impacts on people who would maybe have paid more, or who might be more aggressive with their investments.
Do you get the sense, just when you were speaking during your presentation about for any of the potential private law remedies to be tested, there would probably need to be some sort of class action? It's not as if an individual person would really afford to be able to do that. When you've been doing your research, have you had any sense that anyone's interested, the unions or trying to test any of these things?
No, I'm trying to get some funding just now to do some more research. So I'd quite like to look at this sort of more general question of workers' pension rights and sort of contractual basis being maybe changed or eroded by different sort of regulatory policy. So that's definitely something I would like to do, but maybe Ian's right, maybe the Ombudsman will come in and clarify it for us, and I don't need to write the paper.
Private law doesn't run out just because the Ombudsman is there. Still, private law might turn around and just say there's no duty, but or the duty's quite low, but it's still worth, I think, laying out that background.
I think the difficulty is that most of the financial advisors I spoke to, their general view was that people who had money were taking advice. People who didn't have money were not taking advice. So it's these people who are probably going to be suffering, but unlikely, I would have thought, to bring an action. So it's probably quite an academic consideration, really. But
I mean, there have been cases brought on similar kind of consumer issues, like the Abbey National case about overdraft charges, where that's a kind of classic poor person's financial product issue, but they managed, like, I assume a consumer body got behind them and funded a test case. Now, a similar strategy would be plausible here, provided that you could get the relevant consumer body to be interested in pursuing it.
I don't think the OFT, well, it's no longer in existence, but the OFT used to be able to do that, but I don't think it can anymore.
I think they still can. I think under the
Rich as well can do it under the, it's now the Consumer and Markets
2016,
yeah, if you look at the Consumer Rights Act. It's in there.
So I think, there would be scope for that kind of, or sort of a class action in strict sense is possible here, but a test case which has mass funding because the precedent will affect other people would be possible.
It's going to be in the future. It's going to be 20 years' time, isn't it? Do you think, or would it? You wouldn't realise how bad the product is, really. And
no, I think unless there's some disaster and with some pension provider, I don't think it's going to come up as a question until we sort of have the drip of people's sort of reality of what they have not matching what they thought they had, or what they expected, or what they thought they'd been promised.
Yeah. I suppose the other issue is that if that's the test, if it's a failure in terms of expectations of information duties thing, I think lots of people will struggle to establish that they had any kind of expectation at all. So the sort of standard mis-selling is going to be quite hard to make out because they just haven't thought about it. And if they answer honestly, well, there's no loss here, there's no causation.
And that's what happened in the Abbey National case, because the court turned round and actually said that it came up with this artificial idea that when you enter into a free bank account, you understand that your payment will be the overdraft. It kind of created this artificial thing because people hadn't thought about it in that way.
No, and overwhelmingly people don't think about pensions. Most people I spoke to knew they had information, but even things like technology is often used to give people access to modelling information, and people lost their passwords, they forgot they had it, they didn't know where the internet was, or just there's so many barriers, and I think so fundamentally we almost have to sort of approach it as a policy in a different way and try and work out how we are actually going to make sure that the default doesn't just mean that everybody's on, thinking has been replaced by an alternate default, which may not be the ideal situation, and maybe have subsequent sort of gradated defaults. For example, I think there should be something maybe every 5 years that prompts you to sort of confirm that you still only want to pay 4%, or, now that you're getting a bit older, maybe you should pay a bit more, or have you thought about this or that, or because currently you can start paying at 20 and that's you don't ever have to do anything else with it.
I don't know if Amanda's going to offer personal pension advice to anyone.
I'm not, I don't hold my practice certificate for that anymore.
But do you have any more questions? I don't think we'll give you a customary answer.